Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Yeah, preparedness is the key, right? The 5 Ps. Proper preparedness prevents poor performance. That's a tongue twister. I had to think about that in my head while you were talking, but it rings so true. And not only do you want to interview that expert, but how I've handled cases is I say, you're the expert. Tell me the questions you want me to ask, because I need to educate myself and be able to present your case or my case in the proper way. So I want the expert to do a lot of the heavy lifting in the beginning, but then we'll start poking holes in their case. And I'll have another one of my colleagues come in and do cross-examination, and we'll find other competing or conflicting opinions and ask the expert, so what is your response to this? And how does it apply to my case? And then you can identify it. Not only do you believe that this person is credible, but will a judge and or a jury believe that? And then are you, at the end of the day, sabotaging your own case just because you want to get an expert involved? So I think Rebecca's spot on. You don't want to cheap out on it. You want to make sure that you're hiring the best person for your case and your jurisdiction.
Absolutely. I mean, the Johnny Depp Amber Heard case could give us so much fodder to talk about for days, is because it was so well publicized. And I looked at that expert and I was like, he's a terribly intelligent person, right? As smart as you could ever want. And I was like, this poor expert was kind of set up to fail from the beginning, because what I saw was a lack of preparation. Everything, it's 5 Ps, a lack of preparation. And when he was saying this is not what I thought it was, that means he wasn't prepared by the person who paid for him, right? They paid money for him to be there, but then didn't take the time to prepare him. So that was not, money well spent. There was no ROI on that particular witness that day. The next thing I kind of, we get to the experts, and experts are a wonderful way to get around some of the issues with what kind of evidence you're allowed to present, right? So an expert's allowed to take and read things and then give an expert opinion on them. What type of other evidence do y'all find is very helpful in these types of cases of parental alienation?
Well, in almost every case, whether you have an expert or not, you're going to have a guardian ad litem appointed, and that can be the greatest thing for your case, or it can, really just bring it down. But the guardian ad litem, one of the benefits of having them appointed is they can look at almost everything. So they can go to the school and talk to the teachers and the counselors and the therapists and the family members and, everybody in the world who you may not necessarily subpoena to court, but they can really do a lot of investigation and a lot of background before they ultimately give an opinion or position on what should happen moving forward with custody and visitation. And so they're able to, based on all of that information, give a recommendation. And so you might have some evidence that's not necessarily directly admissible. They can still provide it indirectly to the court in their recommendation as a basis for their recommendation. That comes up a lot with like the child's opinion. So depending on how old the child is and the reason for, their position or their opinion or their preference, they're going to be communicating directly to the GAL and say, this is what I want and the reasons for it. And then that's something that the GAL can turn around and communicate to the court. And you don't necessarily have to bring the child in as a witness, which is obviously something we always want to avoid. So that's definitely beneficial. Or it can be really harmful. That's the thing with GALs, is they have access to everything, and you don't always know how the recommendation is going to play out based on all these conversations and all of this investigation they've done.
Yeah, the guardian ad litem is supposed to be an independent person, right? But they're an arm of the court, and judges rely heavily on a guardian ad litem or GAL's opinion. They don't necessarily, quote, rubber stamp them, but it's hard to get them off of what a guardian ad litem would recommend. But Rebecca, when you were touching on the authority that the guardian ad litems have, it reminded me of a good way to actually impeach a guardian ad litem. If you have one that doesn't give a good recommendation in your favor. And everything you said is exactly what I would suggest to make sure that the guardian ad litem was doing as far as their due diligence and how you can impeach them. If they're not interviewing certain witnesses, why not? Who did you interview? Why did you interview them? What subpoenas did you send out? Why did you send out those subpoenas? And it's, we try not to try and impeach a guardian ad litem because the child is their client. So we take that under advisement, but we also want to make sure that our client is given a fair representation, a fair opportunity to be able to present his or her case. But when you have a guardian ad litem involved, it is so important from the beginning to be as proactive as possible, meaning you want your client to reach out to the guardian ad litem to initiate that first contact. You want to prepare your client for that because you don't want your client going in blind to any of these meetings. And it's not preparing so you can trick the guardian ad litem, it's just making sure that your client feels safe and comfortable in answering questions, but being completely transparent and honest and not berating or insulting the other parent. That does not go well, and it goes the other way. People think that they can go in and just unload and say, oh, my spouse is such a horrible person because of X, Y, and Z. Well, that's going to backfire. You really want to go in and try to say at least something complimentary, right? Like they're a good parent or they mean well or something, right? And that's what you want to flush out with your attorney. And that, of course, with the caveat, it's based on the issues and the allegations in the case. So that's why everything is so fact specific. But one of the unique things in some of the jurisdictions that I practice in is the court can appoint a guardian ad litem, of course, on its own sua sponte, dependent upon the allegations, right? That would rise to the level what the statutory requirements are. Or you can file the motion for a guardian ad litem, and then the court appoints the GAL. But the unique thing is, we as the practitioner, the attorney, can determine, do we want to keep that person or not? And you have 15 days from the date of the appointment to file the motion to disqualify. And it's like that. They're out. So it's a good advantage. It's kind of like a motion to strike or striking a juror, but you only get one. So you want to make sure that you're using it wisely. Just like in 2 of the 3 jurisdictions that I practice in, you can file a motion for a change of judge. So once a judge is appointed, because you have no idea who's going to be appointed to your case. We don't have certain judges that handle certain cases, or there's just some way of assigning them. It's just really random. But once you know who that judge is, if you don't think he or she is a good fit to the case, in these 2 states that I'm licensed in, Missouri and Illinois, you can file a motion to change. And it's granted just like that. You have 30 days from the date of the appointment to file a motion for change.
Wow.
So there's some strategic tactical advantages depending upon where you're at. And going to what you were saying earlier, Charles, that you want to make sure that you have that right attorney involved in the case from the beginning, so they know who do we want to be on the bench, or do we need to get a guardian ad litem? And if so, who do we really want to stay away from? Because the thing is that a lot of attorneys I see get caught up on is, sure, you don't like this one person, so let's disqualify them, but who's going to come in right after, right? So you got to weigh your options to determine.
Yeah, I mean, and that goes to, your attorney is supposed to be helping you strategize, not just, we do have whims where we don't like somebody. And guardian ad litems tend to be wonderful people who really care about children. But man, they're the target of some hate that I would not want to be the target of, because they truly do represent the children. And that means they do not represent the desire of the parent. And, when I practiced, when a guardian ad litem was appointed in one of my cases, I would go to the hearing, or however the guardian ad litem was appointed. As soon as I found out, I reached out to that guardian ad litem. I provided them with my version of an authorization to speak to my client, because, right, I represent the client. They're an attorney. They still need authorization to speak to the client. And the first thing I said was, let me know what you need. Let me be a help to you, because, I think that it's important to understand they're doing a lot of heavy lifting. Like you both said, I mean, the court, it doesn't necessarily rubber stamp their opinion, but the judges are judging them on how well they go out and interview people and go to the school. And if I can help them do their job better, then it is probably going to be good for my client. And, like you said, prepare your client for that meeting. But at the same time, I know some practitioners want to go sit at the meeting, right? They want to go sit there at that meeting. And, I've heard horror stories about practitioners that will not provide the authorization to speak with the client without them there. No, go do it. Go do your job, guardian ad litem. And what that does is, puts the guardian ad litem's guard down. And I will tell you, the worst thing that I've seen a practitioner do is start talking bad about the guardian ad litem to the client, because now you've poisoned the well. Right now, the client's going to react poorly to the guardian ad litem. And even though the guardian ad litem may be the best guardian ad litem to ever walk into that court, your client's going to treat them with a chip on their shoulder. And you're going to lose the case just because you happen to say, oh man, I had that guardian ad litem before and they went against me and I don't understand it. No, they've got tough jobs too, right?
Oh yeah, you're spot on. Be open and honest, and be transparent, because otherwise it gives the appearance of some type of impropriety. Whether or not anything is going on, if you're going to be combative or non-cooperative, you're setting the tone, and that's a bad tone to set.
It absolutely is. And going beyond the guardian ad litem, it's not recent. We had a case in Northern Virginia where the father was being alleged to have abused the child. And so the father, when he was around the child, just video recorded the interaction. And, and then brought the video recording into court, which would normally be hearsay, right? He was recording the child's responses to, do I abuse you? And this is an oversimplistic thing, so it may have been different words, but the idea was that dad was asking if the child thought he abused his dad, if the child was afraid to be at dad's house. The child answered unequivocally no. And the court in Fairfax County actually allowed that evidence in without the child being there for subject to cross-examination. So what would be pretty clear hearsay. Is there anything that y'all have seen kind of in that line where the court lets in more novel evidence to help get an answer?
I've definitely seen some recordings, videos, things like that have been allowed in. And the trick is, you're not trying to admit it for the truth of the statement. You're trying to admit it either to challenge someone else's statement. So if mom got on the stand and said, daughter's terrified of dad, now you're using that piece of footage to contradict or impeach mom's statement. And so you can get a lot of stuff into court either through impeachment or through another method. You're trying to show, the present sense impression. You're trying to show some other aspect of what's going on, more than just the fact that the child is saying no. You're showing that the child is jumping around and playing and, like wrestling with the dad, or, you know what I mean? Just very playful, very happy, very clearly not staged. And then it contradicts everything that mom is saying about how the child acts with dad. And so we are able to get some evidence in that way. And basically what you do is try to elicit that response first from mom, because you have, this evidence that's going to contradict it. Okay, so you would say your child is terrified of dad. And you would say, your child doesn't want to go with dad, or doesn't play with dad, or doesn't whatever. Now I can bring that in an impeachment situation. That's one of my favorite ways to bring in evidence that otherwise you obviously can't get in front of the judge, can't get in front of the courtroom. But now the judge has seen with their own eyes the child smiling and happy and playing, and you can't take that image back out of their head, right? Once it's there, it's there. So that's definitely one of my favorite methods.
Yeah, and just to add to that, because I echo everything you just said for the benefit of maybe evidence being entered that you would have objected to. But look in the background too. So many times I've won a case just because there was something in the background, whether it was alcohol, drugs, or even another individual, and no one pays attention. And so it's already entered in evidence, and you just go back to that, and then that may or may not help your case, depending upon what some of the issues are. So there are many avenues that are available when evidence is entered that you may or may not want to be entered into. But then also, if it is entered into, you still have that parent leading the child on. And in my experience, judges and guardian ad litems really have a very low, if zero, tolerance for when parents are leading children on and they're taking those pictures and those videos just for court related purposes. There's more behind that. And then you have the other problem of, if there is that parental alienation, well, you're helping prove that, or set that foundation. And so you can use that evidence to assist you in your case.
Yeah, evidence is tough. I mean, I remember I had a client and he had a 16 or 17-year-old daughter, and he had been fighting for custody for 5, 6, 7 years, and nobody believed him. He had went through a lot of attorneys who were like, look, man, she's 16 years, 17-year-old daughter, give up. you're not being alienated. The daughter said it to this very respectable therapist. The therapist is on the other parent's side. The other parent, the daughter, seems to be there. And then through a random, so I always believed the guy. He seemed very nice. And through a very random, inadvertent disclosure from the other side, they turned over years of emails between mom, the attorney, and the therapist on how to alienate dad. It was a game plan on how to alienate dad. And it's an inadvertent disclosure. So I had some ethical obligations for that inadvertent disclosure. And I called the bar. Unfortunately, the rules had not changed yet. But at that point in time, I first had an obligation to my client and turned it over to my client and gave him that information. And I honestly couldn't help myself. I stapled the entire email communication chain to a motion and filed it with the court because I couldn't let that one go. And I know for an inadvertent disclosure, that may not always be what you're allowed to do. But the idea, like Rebecca said, is you can't put the ghost back in the box. The judge is never going to unsee that chain of emails. There was some negative comment said about me by the judge for having done that because it's an inadvertent disclosure. What I should have done was turned everything back over to the other attorney and pretended like I had never seen it, I suppose. But I wasn't willing to do that. So when you're talking about, to potential clients who are going through this, what should, my takeaway there was always listen to your clients, right? Just believe your clients. There was no reason for me not to believe my clients. And a very experienced attorney said, you don't get to make the decision whether or not they're telling the truth. You don't get to pull the curtain back and see behind the scenes yet. They come to you and tell you this is happening. Just believe them. What is y'all's advice for what you should do when clients come to you with these sometimes very weird stories that may be a little bit not believable?
So I think you start looking at, okay, well, how can we prove this? You say that X, Y, and Z are happening. How, if we went into a courtroom right now, how could I prove that to a judge? And then we start putting the pieces together. Oh, well, I guess there's some Facebook posts, or there's some text messages, or there's some this, or there's some that, some photos or videos or whatever. And you can kind of put it all together in such a way to present that this is what's going on behind the scenes. And sometimes with parental alienation, it's really difficult to know what's happening behind closed doors, what the other parent might be saying to the child and that type of thing. But if you don't already have a paper trail, then starting to create that paper trail in a way that you're going to be able to present this to the court. So asking to pick the child up, asking for the phone calls, asking for the FaceTime videos or whatever. And then sometimes we see that like the FaceTime videos or the phone calls are really being heavily monitored and controlled by the other parent. So sometimes getting a recording of that and showing the other parent is standing over the child's shoulder, right? Or doing something like that, right? And we can start to put together a timeline and show these are some of the instances where we can see something is going on. And then with the timeline, we know that around this time is when the child all of a sudden said, I hate you, Dad, and I don't want to go with you anymore, right? And so then we can kind of imply this must be what has been going on. This is demonstrating a pattern of what's been going on and the root cause for this problem. So that's really number one, though. When your client comes to you and says, the other parent is doing this, okay, great. How can I show a judge that that's what's going on? And you really brainstorm together with them and start giving them some ideas and asking those questions so that you can start to put it all together.
Yeah, I think it's challenging, right? Because they come in and you have to make sure you're doing your due diligence to flush it out. But we also have that ethical obligation that if it comes up and we know our client is guilty of something, we have that obligation to advise the court, because we can't put on a case where we know our client committed something, whatever that something is. But you're spot on. It all starts with the due diligence. And I like how you suggested to do that. I think that's a great practice tip for all attorneys when the client comes in. Okay, so you're telling me X, Y, and Z. So how can we get there? And explain the process to the client. This is what we need to do, and here's how we'll have to prove it. And we need to get some evidence and just kind of walk them through it so we can not only try to be able to move their case forward in a system, but it's also going to be judging their veracity and their credibility. And if you as the practitioner, the attorney, are having some troubles with that, imagine what a judge or a jury or even a guardian ad litem is going to have. So you can start flushing out some of these issues in the beginning. And I'm not advocating that you withdraw or not take the case. It's just now, okay, if I have some questions or there's some holes, okay, maybe we try to settle this. And what does that look like? And have those discussions with the client. Because you don't always want to just litigate just for the sake of litigating, or even if a client wants their day in court, right? I've had those clients where I don't care what happens, I want my day in court. Well, let's talk about that. What does that mean to you? And sometimes that just means they want to be heard, not necessarily sitting on the witness stand, but they just want to make sure that the attorney knows what their concerns are listening and really zealously advocating for them.
Yeah, and when you're trying to be a partner with somebody going through this process, sometimes partners have to tell you things you don't want to hear, right? They have to say, look, we can't take your case to court, or look, I hear what you're saying, and we got to get some evidence from somewhere. We got to be able to take something into court. I want to thank both y'all today for showing up and talking about what I consider to be one of the more emotional topics that we talk about. Parental alienation is tough, and I want to thank both y'all, because if you're going through this, you need help. And that's my advice. If you're being alienated as a parent, get some help, man.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.